Hi everyone. So today's session is Law of Accounting. My name is Shazia Khan, and the learning outcome we're doing today is learning outcome 2, which is to understand company and insolvency law. But before we go into learning outcome 2, I just want to give you a summary of what we did in the last learning outcome, which was learning outcome 1. So in learning outcome 1, we looked at understanding the elements of law affecting commercial practice. We looked at contract law. We looked at the elements of a valid contract. So how is a contract formed? We looked at how contracts can be terminated. We looked at remedies for breach of a contract. We also looked at the relevant case law in regards to contract law. We then went on to look at the law of agency, and we looked at principles of agency, rights and duties of agents, including partnerships. We looked at implications of the agency relationship and relevant case law. We then went on to look at law of tort, what constitutes negligence, remedies for negligence. We looked at the types of law as well. We looked at public and private law. We looked at the key elements of a contract. So how, if a contract is formed, what a contract is, but when it is formed, what are the key elements? So things like an offer, acceptance, consideration, and then intention, certainty, and capacity. We looked at the Trades Description Act 1968 and the importance of that in regards to providing a service or providing goods for individuals. We then went on to look at the Unfair Contract Terms Act, UCTA 1977. And the relevance of that. We also went on to look at the Unfair Terms in Consumer Contracts Regulations 1999. We then went to look at the elements of a contractual agreement, so how it was formed, and what are the components of a contract. We also watched a video on what is a contract. We then went on to look at what is contract law and what its aim is. We looked at an agreement in law, examples of agreements. So we looked at unilateral and bilateral agreements and the elements of them and why they are important. We then went on to look at the difference between an agreement and a contract and a unilateral and bilateral contract. We then went on to look at agency and the impact on business practices. We looked at the agency costs, separation of ownership and control, agency theory and corporate governance. We looked at the principal-agent relationship, shareholders and directors, and why they're so important in regards to a business. We then went on to look at some prominent business scandals revealed between 1998 and 2008. Things like Apple, Elon, Computer Associates, and looked at the elements of the scandals that occurred. We then went on to look at tort and the remedies around tort law. We identified the difference between contracts and tort law. We looked at the elements of tort, which are things like private nuisance, public nuisance, trespass to land, nuisance, trespass to person, negligence and duty of care. We looked at the neighbouring principle in the case of Donoghue and Stevenson. We looked at the validity of any contract, and we looked at the case of Feldhaus and Bindley and Adam versus Linsell. We then went on to look at the implications of agency relationship for principal and agent, the cost of agency relationships, residual loss, and then we looked at the elements of shareholders and auditors as well. So that was learning outcome 1. Now we're going to move on to learning outcome 2, which is looking at, which the slides are up for now, which is looking at understanding company law and insolvency law. So the indicative content is we're going to look at the formation, financing and administration of companies. So we look at things like procedure of a company, how it's formed, look at advantages, disadvantages, veil of incorporation, exemptions, procedures for the issue of shares, capital maintenance, share transfer, share distribution. We'll then go on to look at directors and officers and shareholders, what they do, their appointment, what the duties are, what the powers are, what happens if they breach the duties, shareholder statutory rights. And then we went on to insolvency. And a lot of this is part of your assignment as well, which we'll go through towards the end anyway. We looked at insolvency, what it is, how administration orders are given, compulsory and voluntary liquidation, and we looked at the rights of creditors and employees and bankruptcy and insolvency in regards to the personal insolvency. So now we're going to go on to look at the key terminology. So what is a company? And it's really important to identify this, and the diagram on the side actually shows the element of what a company is and the procedure it goes through. So a company is a type of business structure that is a separate legal entity from its owners. It's a complex business structure with higher set of an administrative cost because of extra reporting requirements and a higher level of obligation. The structure costs and legal obligations make a company structure better suited to a medium or large size business. The company structure makes it easier to sell or transfer ownership of the business, and a company is an internationally recognized and respected business structure and confers of perception of size. A company, as we mentioned, is a legal entity separate from its shareholders and part owners and directors and managers, so it's separate to them. Veil of incorporation. So the corporate veil is, this concept is, concept gives rise to, or is the corporate veil. Creditors are not able to recover debt from the personal assets of the shareholders, directors, or it must recover them from the assets of the company and the company alone. And in times of war, it is legal to trade with the enemy. And case in regards to the corporate veil is the case of Daimler and Continental Tire and Rubber Company Limited, 1969. The facts in this case are the defendant, a UK incorporated company, was owned by 5 individuals. When the company incorporated in Germany, only 1 individual was British and he held 1 share. It was held in this case that the claimants need not discharge their debt to the defendants. Effective control of the latter was in the enemy's hands, and hence to do so would be to trade with the enemy. Another example of a case is the case of Solomon. Hi Jane, are you on? Hello Jane, can you hear me, yeah? Hi Jane, can you hear me? Oh, okay, so you've said this. Okay, thank you. So we're just going through learning outcome 2, because we did learning outcome 1 yesterday. And we're looking at the elements of, I'll just go a little bit back, understanding company and insolvency law. And we're looking at elements of formation, financing, administration of companies. We're also looking at directors, officers and shareholders and insolvency. So firstly, we looked at what a company was. A company is obviously a legal entity. A company is a legal entity, and it is separate from its shareholders, and it is part owned, the part owners and the directors in the company. Now we're looking at veil of incorporation, and we looked at the Damlier case. We're going to move on to look at another case, which is the case of Solomon and Solomon 1897 in regards to the veil of incorporation. This case was first affirmed that the difference had limited liability with corporate veil. So you know, the veil of piercing the veil of incorporation. So when an exception applies to protecting given by limited liability, it's referred to piercing the veil of incorporation, which means lifting the corporate veil, raising the curtain of incorporation. So when it is lifted by creditors, it makes the shareholders liable for the debts. So any debts they've got of the company, they're liable. It also gets at the personal assets of the shareholders, and in elements to using these assets to recover the debts of the company. So this is what the veil of incorporation actually means, to get the debts recovered of the company. So types of companies that we have in regards to this. So we have different types of companies. So we have public. So when we look at companies, do they all operate in the same way? No, they don't. So many companies don't operate in the same way. They all have their own way of operating, and that's why they're set up. So the way a company is classified depends on other things. So who are responsible for the company's liabilities, who are responsible for how the company's run. So these are dependent on that. Private company versus public company. So the definition is, in the public company, it's registered as a public company, whereas a private company that is not a public company, the name ends with PLC for a public limited company, and for a private limited company ends with LTD. The capital for a public company must not be less than the authorised minimum, which is currently 50,000. And for a private limited company, there's no actual maximum requirement. To raise capital for a public company, it may raise capital by advertising its securities, which are shares and debentures. For a private company, it's prohibited from offering its securities to the public. For a public company, the start of trading must obtain trading certificate from registrar before commencing trade, and for a private company, can begin from the date of incorporation. Directors for a public company, there's a minimum of 2, and the directors for a private company is a minimum of 1. So this identifies the difference between each one. We go on further to look at the private company against the difference between private and public company. So broadly speaking, the difference between private and public companies is that, assuming the public company satisfies the conditions for listing, its shares can be listed on recognised stock exchange, allowing the business to raise capital relatively quickly and allowing members of the public to buy shares. So that's for public companies. The difference between private and public companies, the directors, as we mentioned a little bit earlier, the directors usually control at least one of the majority of shares, and the shares in a private company are rarely traded. It's common for private companies not to pay share dividends. So there's a big difference between private and public company, and there's a need for the difference to identify what are the requirements. consequences of incorporation. So there are a number of consequences separate, being a separate legal entity, there are a number of consequences. So, it's really important when, in regards to your business, being a legal entity, that there are different consequences of this. You can't just set up a business and think that, the elements what apply. So there are a number of effects of, incorporation, such as liability of members. They should be liable. It can also make contract with its own shareholders. It can sue and be sued in its own name. And it can gain the ability to own land or property, as well as perpetual succession. So where a company suffers injury, it is the company itself that must have the appropriate remedial action. And this was identified in the case of Foss and Harbottle, which was, it is a general principle of company law that an individual shareholder cannot sue for wrongs done to the company and complain of internal irregularities. And this principle, as we mentioned, was identified in the case of Foss and Harbottle. So what is company law? Why it's so important when we look at companies and stuff? The element of company law is really important because, it regulates how companies operate. So if you didn't have company law in place, it would be difficult. And, it is the legislation that deals with it is the Companies Act 2006, which lays down specific requirements for companies registered in the UK and what the requirements are. So, it sets out the regulations, the requirements that a company must follow, the different type of companies. It also sets out, that the companies must produce annual reports. It sets out that the companies have to meet these requirements before they become a company as well, so it is Companies Act 2006 is the main act that Companies House will deal with in regard to making sure that the companies are following the provisions of the act and the requirements of this act. So companies law is really important in regards to business when we look at the elements of it. So company law includes parts of securities regulations and insolvencies. So companies law would include insolvency law and securities law regulation. The latter is part of a larger body known as capital markets, to the extent that they apply. In the last 20 years, each area of yours have become highly developed. So you've got company law, which is securities regulation and insolvency law. And then the next one is corporate governance and why that is so important. So corporate governance actually refers to the way in which companies are governed and what the purpose is. It identifies who has the power and accountability and makes decisions. In essence, a toolkit that enables management and the board to deal with more effectively with challenges of the running the company. So, corporate governance is a system by which companies are directed and controlled. So it's really important to have that in place. Boards of directors are responsible for the governance of their companies, and the shareholders' role in the governance is to appoint the directors and the auditors to satisfy themselves that an appropriate governance structure is in place. So it's really important that you have a good structure in place. You okay so far, Jane? Thanks, Jane. So when we look at laws in place. Okay, why there's a need to have various laws in place? Because, you know, there is a need to have these laws in place because companies would not run without these laws in place. So you have laws in place to identify certain concepts. So you have the Companies Act that deals with everything in regards to a company. You have, I'm just going to go through a couple of them so you've got a bit of an idea, but you need legislation. Legislation is pivotal to the you know, instrumental of any company law. You know, it needs to fall within legislation, and it's really, really important that you, as an individual, if you're setting up a company or anything like that, you need to know the legislation, and you need a knowledge of company law, and you need to know the you know, framework of how companies operate. So the first one I'm just going to go through quickly. We've looked a little bit at Companies Act. Insolvency Act covers the laws related to company insolvency and winding up. And then Corporate Insolvency and Governance Act 2020, which is a new one. It looks at the changes insolvency to support companies to carry on trading through the COVID pandemic. Because the COVID pandemic came through, it was difficult for companies to trade, and there was a need for changes. So, you know, these changes came about. Then you've got the Company Directors Disqualification Act, and that looks at disqualifying companies, and then so on. So there's a couple of acts there, and the need for legislation is that you're able to run a company following the laws and procedures. Now we're going to look at 2.1 is to analyze the requirements of company law formation and financing and administration of the companies. And this is really important because this is part of your assignment session. When we look at the assignment discussion, there is an area that looks at this element of it. So although there are different types of companies, such as public and private limited, the most popular are limited liability companies and private limited companies. So they are need, you know, to have these companies. So like we said, a company is earlier associated, which has the character of a legal person distinct from its other shareholders. A company is formed with a certificate of incorporation and is issued by appropriate governmental authority. A certificate of incorporation is issued when the constitutional documents of the company, together with statutory forms, have been filed, and the constitution of a company consists of two documents: a memorandum of association, which states the objects of the companies and the details its authorized capitals, and the second one is articles of association, which looks at the provisions for the internal management of the company. For example, its shareholders, its you know, the general meetings, the board of directors. Advantages of forming a company. You may find it easier to raise finance. You can formalize ownership and voting arrangements. How to form a company. So like we said, a company, it must be registered with Companies House, and you must follow the legislation. So the document to be filed is 1NO1 form, provided with the company name, the director's details, as we mentioned, memorandum of association and an articles of association must be submitted. The management of the company is carried out by its officers, who include directors, managers, and a company secretary. So, you know, it has to have these in place to offer the role of the company, you know, so they have to have these people in place because the company will run smoothly. So things to consider. Consider a company name. So, you know, you need to consider a name that's a company that ends with the name limited. And you need to, it can't be a sensitive or offensive word. It needs to be something that when you choose it, it makes sure that it's important to remember that your company is, if it's not similar to another company, because then you would get into trouble for that, because you would be copied under the company's name, and that would be looking at things like patents and trademarks and copyright. So a company can voluntarily change its name by passing a resolution under Section 78 of the Companies Act 2006. And the Secretary of State requests a change in name in the following circumstances. So the name is the same as to be like an existing registered company, or the name gives so misleading an indication of the nature of the company's activities, or misleading information or undertakings were given when applying for a name when required approval. So the shareholders and share capital, and why they are so important in regards to elements of a business. So share capital is actually shareholders' capital equity. Share capital is different from shareholders' equity because it does not include retained earnings. It's made up of one of the equity owners have put into the company by purchasing it. So there's a difference between both the shareholder and the share capital as well. Share capital is the total value of shares that a company has issued to its shareholder. The value of issued share capital can fluctuate based on the market value of the shares. Issued share capital is an important measure of a company's financial health and its ability to raise any sort of capital. So it's really important that, you identify the element of the difference, because, share capital is literally money put into the company and the amount that's financing the company. So we're going to go on to looking at directors now. So directors in a company, and they are an important part. I think all the elements of people working with this within a company are important. But when you're looking at directors, they have different duties to others. So the duties of company directors include setting the company's strategic direction, so making major decisions at board meetings. Also ensuring the company complies with the legal and regulatory requirements. So as we mentioned the laws before, the directors need to make sure that they are complying with the laws. The reasoning behind it is that if they don't comply with the law, they will be breaching the law. There's different types of directors in different organizations, and company directors have legal rights and responsibilities as well, and can be personally liable for any sort of breach or any wrong that occurs. The company director is an office holder, who means that they have legal status and responsibilities. They are legally responsible, as we said, for the company's business and can be held accountable for its actions. Directors of companies are generally appointed to the board following a formal process, and they are then registered with the company's office. Directors, like we mentioned earlier, are responsible for managing the affairs of the company, and however, some people are eligible to be directors, so it's really important. All companies must maintain proper books and records. Ideally, directors are responsible for making decisions of the companies, and they must ensure that the main thing is that they comply with the legal requirements. So they comply with the laws that are in place. It's really important that they are complying with the laws. Directors are one of the most important components of an organization or a business. They have different duties, and they have to they sit as a board of a company, and they are legally responsible, and they have fiduciary duties like other people as well. And the ultimate responsibility of the director is to manage the business on behalf of the shareholders. So now we're going to look at secretary. So secretary, when forming a company, you will also need to consider whether you like to appoint a secretary for the company. So a UK company may have a secretary, but there's no longer a requirement for a private company to have one. The secretary may be but does not have to be one of the directors, and another individual or company may act as a secretary. One of the main factors to consider when deciding whether to appoint a secretary is that the English law imposes a significant number of duties on the secretary, including the maintenance of minutes, books and registers. Despite these having duties from the company's perspective, a secretary can be a useful appointment in order to ensure the company's administrative requirements are met and that the company does not find itself in breach of Companies Act. So it's really important for the company to have secretaries in place, because there's a need for having the secretaries, and because they will deal with the running of the company. Registered Office AD01. So as part of company formation process, you must also be required to state the intended registered address of the company. A UK company must have a registered office in England and Wales. They will have the address for the formal service of legal proceedings, and any sort of formal documents need to go to an address, so they need an address. It is often convenient that Secretary of State should be based at either the registered office, the secretary, or the principal place of business. If you are unsure as to where the office should be, it should be noted that the company's registered office can be easily changed at any time by board resolution and a form which is filed at Companies House. So it needs to have a registered office. Constitutional documents. The two key constitutional documents that Companies House, which we mentioned a little bit earlier, is Articles of Association and Memorandum of Association. And we'll look at each one so you've got a better excuse me. The Memorandum of Association and the Articles of Association. So firstly, the the Articles of Association. So what is an Articles of Association? In the UK, it deals with the element of written rules about running a company agreed by the shareholders, all guarantors, directors, and the company secretary. They are required under Companies Act to become a public document when a company is registered with Companies House. Or if someone else has come, or Jane twice. Okay. And shareholders invest in the company based on the objectives defined in the Memorandum of Association. And they're entitled to receive dividends and other benefits with its defined scope. Whereas the Articles of Association, on the other hand, regulate the relationship between the shareholders and the company's management. So Articles of Association are where they regulate the management of the company and look at the issue around how the company is run. The Memorandum of Association is binding on the company and its members from the moment of incorporation. Any activity carried out by a company that falls outside the Memorandum of Associations is considered ultra vires and void, providing a protective shield for stakeholders. So it's really important that these elements of both Memorandum of Association and Articles of Association are needed in regards to elements of a company. So now we're going to look at 2.2, which is to analyse the role and responsibility of company directors, officers and shareholders. And I do know this is part of one of the parts of the question as well for your assignment. So we'll have a look at this. So the role of directors, which we had a little bit a look at earlier as well. So the Companies Act 2006 impose certain general duties on a director of a UK limited company. A company acts through two bodies of people, shareholders and the board of directors. And the board of directors are in charge of the management of the company, as we mentioned earlier. Company directors, the directors are effectively the agents of the company appointed by the shareholders to manage its day-to-day affairs. And the basic rule that the directors should act together as a board. So, you know, they have, as a director, they have duties that they must follow. Which are to promote the success of the company. They should act within the powers, so they must act. The Constitution includes its articles of association and resolutions and agreements of the Constitution. They must promote the success of the company, so you must act in the way you consider in good faith. Would be most likely to promote the success of the company for the benefit of its members. They must also exercise independent judgment. So here you must exercise independent judgment and make your own decisions. They must exercise reasonable care, skill and diligence. And that means that you must exercise the same skill and diligence that would be exercised as a reasonable, diligent person with the general knowledge, skill and experience, or the general knowledge, skill and that actually possess. Fifthly, to avoid conflicts of interest, you must avoid conflicts of interest or any sort of interest of the company. And things like the duties could involve not accept benefits from third parties, and that could be things like not accepting any sort of benefit from a third party because you are director and you can't do that. And the other one is number 7 is to declare interest in proposed or existing transactions. So these are some of the duties, and you've got indirect responsibilities that can be by an accountant, so registering for business taxes, so your HMRC as well, filing an annual confirmation statement, filing annual accounts with Companies House, filing the company returns and annual accounts with HMRC, reporting for company changes and registering for self-assessment. So as we mentioned, the company director, again, is responsible for any sort of acts or omission during the course of his appointment and management of the company as well. Next one we've got is company shareholders. So duties of company shareholders. The shareholders of a company are effectively the company's financial supporters. They provide finance to a company by purchasing shares in the company and thus become shareholders and part owners of the company. Shareholders have certain rights and roles and to perform set out in Companies Act and the company's articles of associations. As a shareholder of a limited company, they are protected from liabilities, save for the amount of shares they own but have not paid. So some rights are what shareholders have. Their rights are to attend general meetings and vote. Secondly, to receive a share of the company's profits. Thirdly, to receive certain documents from the company. Fourthly, to inspect statutory books and constitutional documents. Fifthly, to final distribution on winding up the company. So these are some more duties as well. So shareholders also can also be directors of the company. Whilst directors are responsible for the day-to-day management of the company, making decisions, their shareholders have specific roles and duties in relation to the control of the company, which we've had a look at above as well. So attending general meetings, annual general meetings, duties. So the main duty of shareholders is to pass resolutions by voting their shareholder capacity. There are two distinctions that can be voted on as shareholders meetings. So you've got an ordinary resolution and a special resolution. So the ordinary resolution is passed by shareholders if a simple majority of the shareholders present at the meeting vote in favour of the proposal. Therefore, more than 50% of votes cast must favour, usually displayed through a show of hands. And then special resolution, where there is sometimes required by Companies Act in certain cases, for instance, to change the articles of association or for other important or sensitive matters. The articles that can also include a special resolution. For a special resolution to be passed, a 75% majority must vote in favour. If there's specific mention of what type of resolution is required, the presumption is there will be a vote on ordinary resolution. Have you got any questions or anything, Jane? You okay, Jane? So if we look at it, if a shareholder breaches its duties under a shareholder agreement, the company or the other shareholders could bring a claim for a breach of contract against the defaulting shareholder. If you have suffered a loss as a result of defaulting shareholders' actions, they may be able to bring a claim for damages against the shareholder. So if there are elements. Okay, thank you, Jane. So if you have any questions, if your mic's not working, respond in the chat and I will answer them. So 2.3, the next one, explain the process of insolvency for a business organisation. So when we look at insolvency, the formal insolvency process is liquidation. And that is where the company is used the sole purpose of closing the company down and dissolving it from its company's register. So, you know, companies will do that. And liquidation is the process of closing a limited company, selling assets and dissolving them from the office register. You know, this is where the company comes to an end and there's no need for the company. So the insolvent company. So the explanation of for winding up involved insolvent companies, and when in the mid-1980s, the law governing insolvent company winding ups was moved out of the company legislation into specific insolvency legislation. It made the same sense to deal with solvent winding ups, and this is all done under the actual it's all done under the Insolvency Act to 1996. You know, there's different ways for you know, when a business becomes insolvent, you know, there is the fact that there are options available to them and they have to get an insolvency practitioner who will guide them on the process. Once the insolvency practitioner has concluded that alternatives are not available, it is concluded that the client is insolvent, the correct insolvency procedure for the client will be decided on. So, you know, it would be up to the practitioner to help you here. Insolvent companies, as we looked at, next one is insolvency and administration. So there are stages of insolvency. So when a business cannot pay its debt, there's a rescue strategies, which are restructure, which is where the financial or operational restructure by reducing costs or increasing sales. Under the rescue strategies, we have equity investment, which is where investors share capital in return for funding. And then we have also informal creditor arrangement, where there's an informal agreement to repay debts to a small number of creditors. And then we have the company voluntary arrangement, so where the formal agreement to repay debts must be to creditors must be approved by the creditors who vote. And then finally, under the rescue strategies, we have the formal procedure where insolvency practitioner is appointed as an administrator to take control. And then within the insolvency, if there is a rescue strategy, if there's not, then the final thing is winding up strategies, which is liquidation. And this, if no longer viable, an insolvency practitioner, as we mentioned earlier, is appointed as a liquidator and takes control of winding up the company. So there are the two elements of it, but this, the main one, which elements that happens is that there are rescue strategies in place, but if there are no rescues that can happen, there will be compulsory liquidation, is where a formal insolvency procedure which results in a company being forcibly closed, and the compulsory liquidation process typically initiated by the creditors of the company through a winding up petition. So, liquidation is a specific form of insolvency, one of the formal insolvency processes applicable to companies. There are rescue strategies, but if they cannot be dealt with, then they will, go into liquidation and wind up. We've got securities regulation as well, which is another really important element of the financial element of it. So the aim of securities law is essentially to provide protection for those who decide to invest in their properties, money in securities. The term security covers complex range of investment products, including products unrelated to companies. Securities regulation is part of what is often called finance law. Finance law can be viewed as made up of three parts: banking law, the regulation of those who conduct investment processes, business, and the markets of which investments are traded. Global financial crisis of 2008. The reform of UK law is the result of both UK and EU initiatives. Most of the changes relate to the regulation of banks and the realignment of the regulatory responsibilities. Realignment has been affected by the Financial Services Act 2012. The Financial Services Authority, FSA, as such, has abolished its functions and split two regulatory bodies. So you've got the Financial Policy Committee, FPC, and the Prudential Regulation Authority, PRA. Fortunately, part of the change of the framework of securities regulation has remained intact. So the global financial crisis had a great impact on the global financial system and, sent shockwaves through the system in regards to what happened at that time. The key securities regulation statute in the UK remains the Financial Services and Markets Act 2000, FSMA, as amended most recently by the Financial Services Act 2012. The 2000 Act established and empowered the main securities regulator to make detailed provisions governing securities, and those detailed provisions were found in what is now the FSC handbook. So 2M1, advise on the insolvency process for a given situation. So insolvency, as we said, is a company is insolvent if either does not have enough assets to cover its debts or it is unable to pay its debts as they fall due. An individual is insolvent if he or she is unable to discharge his or her debts as they fall due. There are a number of reasons why a company might become insolvent. So loss of market, management failure to acquire adequate skills, fraud, loss of long-term finance or other reasons, excessive overheads, new ventures, expansions, or any sort of acquisitions. So insolvency case studies. So here you've got a case study 1, which looks at the use of insolvency system by creditors to initiate bankruptcy liquidation proceeding. The client C is a local supplier of goods in your country. One of the client's customers, a local privately owned limited liability company, manufacturing company, has failed to pay a debt due to the client in the local currency, equivalent to 10,000 as a result of cash flow problems. The debt is more than 30 days overdue. There is no dispute regarding the underlying transaction that gave rise to the debt, and the debtor has no valid defence for the non-payment of the debt. The client now asks for your professional advice on an action that the client can take under the insolvency law of your country to deal with the apparent insolvency of the debtor and the process that will be involved in obtaining final order against the debtor. So you need to note that effective final order means the making of an order or the pronouncement of a judgment which has effect that the affairs of debtor will thereafter administered under insolvency law, whether by a bankruptcy, liquidation, or other form of insolvency process. So this is an example of a case study that you will need to look at when it comes to your assignment. The next part is looking at 2D1, which is aspects of capital maintenance and what that actually involves. So capital maintenance, a concept states that businesses' net worth is said to have been maintained if net assets at the end of the period are equal to or more than the net assets at the beginning of the account period, keeping aside any withdrawal during the said period. In other words, it states that company must book net income only when it is recovered its capital or its costs. For example, an adequate amount of capital has been maintained. Capital maintenance theory suggests that one must not book profits until a sufficient amount of capital is maintained in net assets. So, the capital concept is that profit should not be recognised unless a business has at least maintained the amount of its net assets during a period of time. The prime objective of capital maintenance is to safeguard stakeholders' interests like creditors and shareholders. Companies will ensure timely compliance to avoid penal provisions or damage to their brand value with statutory requirements of maintaining capital requirements. Maintenance of capital ensures the safety of shareholders and the creditors' invested funds. This will in turn affect many potential vendors and investors who are actively looking for investing. So the capital maintenance idea is concerned with the net change, as we mentioned. The rules of maintenance of capital exist to prevent a company reducing its capital by returning to its members, whether directly or indirectly. This means that as a general rule, a limited company cannot reduce its capital. So, however, an exception of this general rule is reduction of capital under Section 641 of the Companies Act 2006. A company can reduce its capital at any time for any reason, such as reducing or cancelling liabilities, return capital in excess of company's needs, or cancel the paid up capital that is no longer represented by assets. So we've gone a little bit over the time, but we'll just carry on and finish off. Procedure for public companies. So they pass a resolution. This diagram shows what is the procedure for public companies. So they pass a special resolution, apply to the court to confirm the special resolution. If reduction involves one of the first two methods above, court must require company to settle a list of creditors entitled to object The court must confirm the reduction until it's satisfied that all creditors have either consented to the reduction or had their debts discharged or secured. And then finally, the company must file documents with the registrar. If the share capital of a public company falls within 50,000, it must re-register as a private company. The procedure for private companies, you pass a special resolution supported by a solvent statement. The solvent statement is a statement by each of the directors that the company will be able to meet its debts within the following year. A solvency requirement made without reasonable grounds is an offence punishable by fine or imprisonment, and then copies of the resolution, solvency statement and statement of capital must be filed with registrar within 50 days. Additional information in regards to additional reading for yourself, things like treasury shares, what they are, what are the elements of treasury shares, and the general rule that shares which are purchased by a company must be cancelled the amount of the company's share capital account reduced by the nominal value of the shares. The exceptions to that you could look at under section 724 of the Companies Act 2006, where companies listed on the stock exchange or the alternative investment market can buy, hold and resell the shares. Or you could look at section 730 of the Companies Act, which states that where treasury shares are cancelled, the company must deliver a return to the registrar no later than 28 days after the shares are cancelled. These are some additional reading for you to do in your own time. So the notice, again, must be accompanied by a statement of capital, which must state, with respect to the company's share capital, immediately following the cancellation, it must look at the total number of shares of the company, the aggregate nominal value of those shares, for each shares, prescribed particulars of rights attached to the shares, the total number of shares of that class, and the aggregate nominal value of the shares of that class. The amount paid up and the amount unpaid of each share on account of nominal value of the share by way of premium. And treasury shares can be also created when a company initially issues shares. The treasury shares can be created when a company actually issues, shares to the public, but keeps a portion in its treasury to be sold at a later date. There are two accounting methods a company can use, as we mentioned, cost method and par value. With the cost method, a company lists the amount reissued in the contra equity account, and the total buyback amount is listed as debit, and total cost of resales is listed as cash under credit. Treasury stock, or treasury shares as it's referred to, as we mentioned, the number of shares that company wishes to retain with itself. Sometimes it's also termed as reacquired shares. It's recorded in the balance sheet under the contra equity account, as we've just mentioned. And the whole point of this the shares is that it's outstanding stock that has been repurchased as is being held by the issuing company. So it's there to hold the shares. So for later on, if they want to plan to sell it, how they would sell it, and they would keep that shares. And to hold the treasury shares in the company, the shares bought back by the company must be in accordance with the Companies Act and must have been purchased out of the distributable reserves and not out of capital. So they need to bear that in mind. And the use of treasury shares has increased, if you're looking at it in today's society, since 2013, when the law changed to allow private companies as well as public companies to hold shares in treasury. So there has been an increase in that, and they are used quite often. So that is the additional information on treasury shares that you can read up in your own time. We've now finished the session. If you have any questions, please ask. If not, I will see you in the next session, which is Learning Outcome 3. Just some of the references that we've used in today's session that you can click on and get some information around that if you need to. And there's additional reading on Moodle for you to go onto, and ebooks that you could go onto Moodle for. And also we've listed some additional reading for you to do there as well. Refer to ebooks and journals on Moodle, as I've mentioned. Any questions around any questions around the session, or any questions around any submission of the assignment or anything like that, you need to email learnerwork@ukvarsity.co.uk. The assignment submission is 2 weeks after the completion of the unit. So we've got once we've completed the elements of Learning Outcome 1, 2, and 3 and 4, then we would be just doing the assignment discussion session. Again, if you have any questions around any areas or anything, please email learnerwork@ukvarsity.co.uk. Thank you for attending today's session, and I will see you at the next session, which is Learning Outcome 3.